For 14 years, our David Hammer has been investigating the causes and effects of the BP oil spill, the worst environmental disaster in U.S. history. Tens of thousands of coastal residents and cleanup workers have claimed exposure to BP's oil and cleanup chemicals made them sick.
But only one of them took BP to court head-to-head and won. Here's David with a unique story of the man who beat BP.
In 2010, John Maas joined thousands of Gulf Coast residents to help BP clean up the largest oil spill in U.S. history.
I had just got my master captain's license, and I was preparing to start a charter business.
He used his boat to spot oil and put down absorbent boom to protect the marsh. Here, a video camera embedded in his sunglasses records him reporting that his boat, his equipment, he and his crew were all soaked in oil and a cleanup chemical called Corexit.
Anywhere oil got on it, it won't come out, dude.
Maas was quickly diagnosed with respiratory conditions and impaired vision.
It got to the point where I was having panic attacks at night because I couldn't breathe.
In 2012, 2 years after the spill, BP signed a class-action medical claims settlement, admitting its oil and cleanup chemicals could have caused workers' illnesses. The oil giant agreed to pay $60,700 to those with chronic conditions. But then in 2014, something strange happened. BP came back to court and argued that any chronic condition diagnosed after the settlement should be considered later manifested, as if, like cancer, it only showed up years later. Suddenly, it didn't matter when the illness actually manifested, only when it was diagnosed as chronic by a doctor. Instead of $60,700 checks, those claims were forced to a back-end litigation option, or BELO, to fight BP in court one by one.
I think that's wrong, dead wrong.
Donald Dumas is one of 22,800 workers who qualified for medical settlement payments. But his conjunctivitis wasn't diagnosed as chronic until August 2012, 4 months after the settlement. So he had to file a BELO case. In 2021, his case was dismissed, along with over 4,000 others.
All these years, they don't even want to compensate you for nothing.
Houston-based attorney Howard Nations represented thousands of those claimants, including Maas for a time.
This was a highly successful scam by BP. After congratulating them on it, they got away with it apparently.
Nation said his best expert told him the BELO cases were unwinnable. Did you kind of like give up on these cases?
We didn't give up. There was no chance in hell. We had no expert witness, so there was simply no reason. There was no reason to continue with the cases.
But you took it into your own hands and you got paid.
Oh, you bet I did. You bet I did. I don't get, David, I don't get my ass kicked.
That's right. 14 years after the spill and 10 years after thousands of cleanup workers were forced into a supposedly unwinnable back-end litigation option, John Maas is the only one to win a BELO claim against BP. And for part of that time, he did it without a lawyer. Did you ever feel overwhelmed with all of this, not being a lawyer and doing all this stuff on your own?
Sheltered by ignorance.
What do you mean by that?
I felt like Jethro Bodine in a federal court. Jethro ain't afraid of no judge, and I'll throw any motion out there I need to throw, and I'll write them, I'll misspell them, I don't care.
Yeah.
They have to liberally construe my motions.
He made one motion in New Orleans that changed his whole case. Now, the first time John Maas beat BP was when he got his case transferred away from the Gulf Coast to the Middle District of Tennessee, and eventually here to the federal courthouse in Cookeville, Tennessee, about 30 minutes down the road from his mountain home. What do you think when you come out here on this deck and you look out at this beautiful view and you think, man, this is not only beautiful, but it gave you the opportunity to have this case here in Tennessee?
I wish everybody down there would come up here and breathe some good air and probably live a little bit longer.
Now that he had his case in Tennessee, Maas needed an attorney to bring it to trial. He came to Murfreesboro, Tennessee, without an appointment, to the offices of Ken Berger.
I think they thought we're coming up here to Tennessee, and we're probably going to be dealing with Gomer Pyle, attorney at law, in what do they call it, Murfreesboro, Tennessee? We're going to be dealing with some yahoo.
They thought you were a country bumpkin and you wouldn't be able to do anything with them.
They thought that Captain Maas would not find his way to an attorney who knew how to handle a complex toxic tort case.
If that is what BP thought, they were dead wrong. Berger has over 40 years' experience, mostly with medical malpractice claims. And unlike the big-name lawyers on the coast, he kept his arguments simple.
First of all, you got to prove general causation. This stuff can cause this harm. Then you got to prove specific causation. You were exposed to it. You weren't in Atlanta, you were in the Gulf. Your doctor who's treating you says, yes, you indeed have this advanced stage of asthma because of your chemical asthma exposed to this Corexit saturated oil. So why not just say that plainly and simply?
Maas's doctor testified that exposure to Corexit caused his chemical-induced asthma. Dr. Vina Anthony from the University of Alabama, Birmingham, testified about her research on the effects of Corexit on human cells.
She is the beginning point on the discussion about what Corexit will do to your body.
BP tried the same arguments it used to get thousands of other claims dismissed, but Chief Judge Waverly Crenshaw wasn't buying it. He wrote in his ruling, BP's argument fails.
I was fortunate that it landed in a court that did not have a narrow view of general causation.
That perspective is very different on the Gulf Coast, said Miami-based lawyer Craig Downs. He, like Nations, represented thousands of medical claimants against BP. He said laws adopted by conservative pro-industry legislatures make it much tougher to prove someone's sickness was caused by chemical exposure.
Over the last 5 years, we've had to dismiss a lot of these cases due to the standards that were being mandated by the 5th and 11th Circuits. They're very difficult, very high bar.
But Tennessee is in the 6th Circuit. Judge Crenshaw rejected BP's claim that Maas should have to prove a specific dose of Corexit caused his respiratory problems. That sent the oil company to the negotiating table, and that was red meat for John Maas.
They were taken back at my crudeness.
After 9 hours, BP settled. Berger is careful not to disclose any of the confidential terms. His client, not so much.
Yeah, I got $110,000 from BP, and I'll be happy to show you the confidential settlement agreement. BP's lied to me from day one on this issue. BP hadn't told me the truth about a damn thing. They think I'm gonna abide by their confidential settlement agreement? You gotta be kidding.
I caught them with their pants down, and they're not going to be caught with their pants down again.
Even Maas admits his success defies explanation and the very fairness of our court system.
And you're the only one who knows what it's like to actually succeed.
That's a shame, isn't it? This story is not about how I won, it's how everybody else lost.
David Hammer, WWL, Louisiana.
Maas's case raises serious questions about why different standards are used to prove chemical exposure depending on where you live.
Federal Judge Ivan Lamel in New Orleans recently said the issue was, quote, very ripe for the Supreme Court to resolve.